So there were some fireworks in the courtroom not too long ago here, just about a week ago, with attorney extraordinaire John Dillon, Second Amendment attorney, fantastic guy. This was knife rights versus Bonta, which was just as much a Second Amendment case as the other gun cases that he and others have been a part of. And I wanted to have John on to talk about exactly what happened and where we are with that case. So without further ado, John Dillon, how are you, man?
Good. How are you, man?
Good. Thank you for being on the show. So tell us, just lay the groundwork for the case. Knife rights versus Bonta. What's going on with that case?
Okay, yeah. So this is a case that challenged California's ban on switchblade knives. So any knife that opens automatically that has a blade length of 2 inches or over is prohibited under California law. You can't buy them, sell them, transfer them, possess them, carry them, anything like that. The law was passed in, I want to say originally listed shortly after the 1958 Federal Switchblade Act. I never since we were banned in California. With the Bruin decision coming out in 2022, we decided it'd be a good time to challenge the law when it comes to switchblade because, the Second Amendment talks about arms. It doesn't talk about guns, the firearms, or hand down to rifles. So anything that you can use as a weapon of offensive defense, according to the Supreme Court, is an arm. So
What what
we
what
thought we
interested
jumped on
you?
it.
What interested you specifically about this case? When this case was presented to you, or when it came up, what made you go, "Oh yeah, this is something I want to sink my teeth into"?
Yeah, I think the main thing was the stupidity of the law. So, a switchblade, it's a pocket knife. And, I in Boy Scouts, I go outdoors, hunting, hiking, all that. I've had pocket knives since I was, I think I got my first pocket knife when I was 4 years old. And I still have it today. Not, just like I own guns and other arms and stuff, I own knives. And when I looked at the law and reviewed everything and saw that, look, they're banning against simple pocket knife that's common everywhere in the country, trying to make some weird claim that they're somehow more dangerous than other pocket knives because of the way they open. And it's a completely absurd notion. And I thought that challenging it on this level would be good because, if we do the firearms cases, judges, juries, DAs, prosecutors, everyone's hackle raised up as we bring up guns in the courtroom. And you obviously have a big bias going in the courtroom in California against any type of gun show. And it was interesting to me that knife cases, they didn't seem to raise these hackles up as much as a gun case. Like you're arguing the same law, you're arguing the precedent and the same constitutional analysis. I thought that would be a nice way to challenge these laws, get some better precedent with regard to curb drug like how the courts analyze these cases. Here we go from there.
And what's the law? It can't be any folding knife cannot be more than 2 inches. Is that the law?
So it's switchblade knife. So it's for
Oh, so
simple
only
terms,
switchblade.
yeah, switchblades. What California, their definition of switchblade would encompass what you typically think of as a switchblade, where you press a button, the blade comes out either out the side of the knife, out the front. But it also would include butterfly knives, which that the teeter case was about out of Hawaii, and then it also includes gravity knives. They're the broad definition of what a switchblade is.
Okay, but folding knives can be more than 2 inches, right?
Yeah, so you can have a manually folding knife.
Or spring assist.
So you have a knife like this. Oh, let's pull it back on the camera. And I manually open it. This is a pocket knife. You can have that. That's fine. No restriction on ownership or carry. You can also have these knives again, simple pocket knife. This is what's called an assisted opening knife. So it has a spring that is opening the knife, but you have to press on the blade in order to get it to open. Now, switchblade knives, and, that's where you just press the button and it opens up. So you don't have to touch the actual blade to get it to open. Those are what's prohibited under California.
I feel so much safer that those.
Yeah, yeah. Exactly. When you look at it and you see it in person, you just shake your head and go, wait, why? What's the difference? Because fundamentally, any folding knife can only cut or do any damage if it's open and like the blades exposed. The way it opens really doesn't matter. If it opens manually, assisted, or automatically, you can only use the knife once. So it just makes no sense when you start hearing arguing.
So I feel like this is a law that like came out like 6 months after West Side Story or something stupid like that. I mean, how did this?
What happened is in 1968 they passed the Federal Switchblade Act, which banned interstate commerce for switchblade. And I have a stepper challenge out of Texas challenging that. Right now they're around at the Fifth Circuit they were revealed. But short and all of that started from a Women's Health magazine article that was written by someone that had no credentials of any kind, literally writing this giant piece stating how all the youths of the United States are killing each other, stabbing each other with these immensely dangerous blade knives. It was all made up, no factual basis whatsoever to support any claims, but that led to the Federal Switchblade Act, which Congress of course passed. And then a bunch of states right after that, including California, also started implementing switchblade laws. And it's all due to the West Side Story movie and its article, this single article that was written that started the trade.
Wasn't part of the reasoning on this one that it's unusual to use a switchblade? Like that's
Yeah.
part of so if it's unusual to use a switchblade, why do we need to ban them?
Yeah, so here's the argument breakdown, because the switchblade knife, as we talked about, it's just a pocket. There's no actual real difference between the alien knife. So the state couldn't do what they've done in small weapon cases, or what they call assault weapon cases, or firearms cases, where they try to control it and prove to the court, like, look, these guns are so much more dangerous. They're used these last shooting. They're way more lethal than these other guns, which is all BS. It has nothing to do with constitutional analysis, and the courts should just reject it entirely. But that's what they do, and the courts like to rely on that in making their decision, at least so far. But they couldn't do that when it comes to switchblade. They can't say a switchblade knife is more lethal than another knife. It's just a knife. So in this case, under the new Bruin standard, it's the threshold question. Does the Second Amendment protect the conduct in question? The plain text of the Second Amendment, and quite clearly protects the right to keep and bear arms. Switchblade is an arm in every sense of the word, and keeping and using it and carrying it all falls under that. So right then and there, the constitutional analysis should put the burden on the state and then judge up liability law. They can't do that. So what the state did is, instead of arguing with the text, which is a threshold question, they started adding all these extra conditions and qualifications on what you need to satisfy in order to be considered an arm under the plain text. So Heller already said an arm is any weapon of offense or defense that you can use to hurt another or defend you. And so for example, that's it. Questions answered. But the states had no, even though switchblades are knives and they are arms under the broad definition of an arm, in order to be a protected arm under the text, they said plaintiffs had to show that these specific knives were commonly used in self-defense area. So not that people carry them for self-defense. They were trying to argue that we had to show a certain number of people actually use switchblade knives in self-defense in order for it to be considered. So they added an stuff on.
So they're the ones that made it uncommon by banning it, and now they're saying, well, people don't really use this that way. Yeah, you banned it. That's why it's uncommon.
Yeah, well, and again, we provided this all sorts of evidence, even though it wasn't even our burden in the case, to show that they're common in America. There are millions and millions of these throughout the country. Back in 1950s, just two manufacturers alone were producing 1.2 million Switchblades a year in the United States. There's probably 3 manufacturers and mall manufacturers Switchblades. So we're making way more in this country than we ever have. So they're common numerically. Also show that they were common jurisdiction. At least 45 states allow Switchblades to be exempt from the community on them. And then we also show just categorically a blocking. So if you think about anyone who does not have some sort of proclamation there, it's probably one of the most widely open farms in the country. So in that sense, so just in companies everywhere, because they're just that pocket knife and this shouldn't be banned. And we showed all that the state had no evidence to the contrary. They literally provided no evidence in the case that would contradict anything we provide. They just said, no, that doesn't count. You got to show that they're used in self-defense art. And when we had an oral argument last week, it was actually interesting. One of the judges on the panel going after the state pretty fairly by saying, well, where in the text does it say that you have to use them in self-defense in order for them to be considered arms or for them to be considered protected? And the state did not have a good answer.
I mean, technically, anytime you have it, whether you're holding it or it's in your pocket, you're using it for self-defense. You know what I mean? Like, you don't actually have to stab somebody for you to...
It feels like they're trying to incentivize us actually needing to protect ourselves. Hopefully we never have to stab somebody.
I know.
Hopefully we never have to shoot somebody.
Like the judges are going, look, unless you start stabbing people, we're going to ban it.
Look at this, too. That argument that they say, you got to use it self-defense. If the court were to adopt an argument like that, you're telling me now that this was the argument. Unless you show that they're used in self-defense, commonly, like all the time, it's not a protected arm under the Second Amendment. So I got a bolt-action rifle behind me. They're not commonly used in self-defense. The lever-action rifle, not commonly used in self-defense. Single-action revolver behind me, not commonly used in self-defense. There's all sorts of firearms. Now, if they adopted this type of analysis, that would magically not be protected arms, which is patently absurd. No one actually would believe that. I mean, even the craziest gun control nuts have already said, well, we're not trying to ban your hunting knife. They're perfectly protected. Those are fine. Right? That argument would literally get rid of protection of the Murph gun. It's an absurd argument.
I'll tell you what we're going to do. We're going to have a gun owners radio event, and we're going to get as many people as we can to show up, and we'll document. We'll just all poke each other with a knife, and we'll document it, and that's going to help your case, John. I think,
There you go. It's self-defense, or you have no idea you stab your post.
I see the headline now. Gun nuts using knives.
So what happened with the what's going on with the case? I saw some of the arguments. I saw some of the exchanges, and it looked like you got a bad pull when it comes to the judges that were assigned to your case. I think he was in front of 3 judges, and those 3 judges, you didn't look like you had. Let's just say Benitez wasn't on that panel.
So the poll I got wasn't the best. I think it was a Biden appointee and 2 Clinton appointees, which I would love to say that doesn't matter and that judges are completely objective. Where they vote or who them does not indicate where they will fall on certain issues as law. Yeah, like I said, I'd love to say that, but I don't think I honestly can.
I used to like to pretend that it didn't matter, and I think there was a time when I wasn't pretending. I really had this this kind of this pure, gee golly gosh attitude of, no, it doesn't matter. They're there to do it. But in all honesty, they've made it matter. The judges have been the ones that have made it matter. They're the ones that are, making completely ludicrous arguments, the ones that were appointed by Clinton and Obama and Biden. They're the ones that they've made it matter. They've convinced me that it matters who appointed you. It's not perfect. I've seen some folks appointed by pro Second Amendment presidents who still screw things up, but it's definitely an indicator.
Yeah. So I knew it wasn't going to be the friendliest count going in. But I do say they do they ask hard the other side as well. And at least in my opinion, I do not believe the state had good answers at all. I mean, at one point, the state couldn't even make up their mind about whether they've in possession in the home. They took the position initially that possession in the home wasn't banned, but then they said it was. And then the court was like, well, what we're talking about, you said this, wearing the law doesn't say that. And then they flip-flopped again. To be honest, at this point, I don't know what the state's position is on whether they think it's banned in the home or not. Wow. I would say, yes, the law says it is banned in the home. So it wasn't great on their end. But yeah, we knew we were going to have an uphill battle. It's not an uncommon situation for the Ninth Circuit. But I believe while they had hard questions, they also had hard questions on their side. Or I believe we see good answers on our own.
Okay. What's the next step? Where are we at with the case?
Wait. I know that's the answer that no one likes to hear, but now we wait for panel. And depending on that decision will kind of dictate where we go. I mean, generally, from memory here, I don't think I've seen any Second Amendment case that had a request for consideration for an en banc panel after the Ninth Circuit panel decision came out that was denied. So generally, unfortunately, when you have a Second Amendment case, after a panel decision, or whether or not it is in your favor, the next step usually involves full panel of judges.
All right. Got it. Awesome job. Way to fight the fight. Am I going to see you at San Diego County Gun Owners' 10th birthday party on November 6th? Are you going to be able to make it? You've been with San Diego County Gun Owners from the beginning, so I'm hoping you can come and have a piece of cake with us.
Yeah, I'd love to. What's the date?
November 6th. Go to SDCGO.org and the flyer's there, but it's November 6th. It's at Good. So there's another reason for you to come to our celebration. You can meet the handsome John Dillon. And by the way, we confirmed before this interview that is not a virtual background. That's his actual that's his actual office.
It's the coolest.
When I appear, great reaction.
That's awesome. John, thank you so much, man. Appreciate you.
All right, have a good one, guys.
All right, bud.
Thank you.
If you liked that segment, be sure to give us a like, a comment, and go to youtube.com/gunownersradio and subscribe to our channel. Be sure to share us with a friend. Every view counts.